Once again, the Teflon Don, Donald Trump, has his back up against the wall, this time in the Stormy Daniels criminal prosecution. Why does he seem more worried about this case? And are his lawyers using the best defense strategy? Let's do a legal deep dive into the Stormy Daniels hush money trial. What's good, people? Attorney John Mobley here. Well, up until only recently, the Teflon Don, Donald Trump, has lived up to the moniker I've given him. In virtually every case, he's been bulletproof. The Russia investigation, the Ukraine scandal, the January 6 hearings. Every attempt to nail him has come up nil. He has been untouchable. Now, this time, the Stormy Daniels criminal prosecution seems different. For some reason, he clearly wants no part of this case. He has made repeated attempts to delay this case. He's alleged pre-trial publicity. He wants to recuse the judge. He wants to change the venue. You name it, he's alleged, all to avoid going to trial. But what's the problem? He's got the money to hire the best lawyers. He's publicly maintained his innocence and said all the allegations are untrue. The state's main witnesses are a porn star, a tabloid journalist, and a disgruntled, disbarred ex-employee. What's the problem? Why not have your day in court and show the world your evidence and challenge all of these nefarious false allegations against you? Well, this case is different than all the others. First, let's talk about the timing. This trial couldn't be at a worse possible time for Trump. He wants to be out campaigning with the presidential election right around the corner. He wants to be out getting his message out to his supporters, firing up his base, getting them motivated to show up at the polls. He does not want to be stuck inside a courtroom day in and day out under a gag order. Number two, the jury is not his political cronies. When he was under the investigation for the Ukraine scandal or the January 6 alleged insurrection, in order for him to have a negative outcome, it was necessary for Republican congressmen and senators to vote against him. That was never going to happen. So like I tell my clients, imagine being on a jury and accused of a crime, and half the jury are your friends and your family. Doesn't matter what the evidence says, they're not going to convict you. However, in this trial, he's facing the judgment of 12 jurors who are sworn to be fair and impartial, who don't have any allegiance or fealty to him, who presumably, if the evidence justifies it, will convict him. He lost the last two civil trials. Trump has seen what can happen when his fate rests in the hands of a fair and impartial jury. He got hammered, first with an $83 million verdict in the Jean Carroll case, and second with a $355 million verdict in the civil fraud case. That's not just losing, that's getting beaten up and thrown out a window. By the way, on a side note, there's actually a word for getting thrown out the window. It's called defenestrate. So, after seeing himself be hammered in back-to-back huge civil verdicts, he knows there's a real possibility he could lose his trial and be convicted. Number four, this is a criminal prosecution. Unlike the other cases, if he lost, he would get hit with a civil fine or some type of censure. Not in this case. If he loses this case, he could be a convicted felon and he's facing prison time. And right now, he's trying to get in the White House, not the big house. And let's talk about the witnesses in this case. Yes, David Pecker of the National Enquirer is a sleazy tabloid journalist. Yes, Stormy Daniels is a porn star. And yes, Michael Cohen is a weasel. He's a disgruntled ex-employee, a convicted felon, and the disbarred ex-attorney. Those are the state's main witnesses. However, here's the reality. Before Trump ran for president, that was his inner circle. That's how he rolled. And David Pecker, he's not Trump's enemy. He likes Trump. He testified about their catch and kill system, where if there was a negative story about Trump, they would find the person, they'd buy the story with the plan to never publish it in order to protect Donald Trump's reputation. He also testified they continued to do that once he ran for president in order to assist him in his campaign. And yes, Michael Cohen is a weasel. But when Trump was running for president, Cohen didn't rush to set up a false corporation, transfer $130,000 of his personal funds to the corporation, and then pay that money to Stormy Daniels for a lap dance. I've had plenty of cases, criminal cases, where the main witnesses against my client were drug dealers, criminals, unsavory individuals. And I'll have my client look at me and say, hey, how can the jury believe these people? How can they convict me based on the testimony of unsavory characters like that? And I have to tell my clients a couple of things. Number one, these are the people you hung out with. This was your circle. So anything you want the jury to think about them, they're probably going to think about you as well. Number two, it's one thing for me to attack the credibility of one witness or a couple witnesses. But at some point, when you have multiple witnesses, even ones with credibility issues, even ones that are criminals and are testifying under some type of plea agreement, when you have multiple witnesses that are in your circle and they have a history with you and they all give details that are all consistent and line up, that is a problem. And it is extremely difficult to try to persuade a jury that all these people are all banding together, making up lies solely just to get you. Now let's take a look at the defense. So what are Trump's lawyers saying? Number one, they're saying that the allegation of Stormy Daniels is not true, that Trump did not hook up with her 10 years earlier as she claimed. Number two, although he paid her off, he wasn't paying her off because he's worried about the presidential election. He was paying her off because he didn't want his wife to hear an allegation, a false allegation, that a decade earlier he had an inappropriate relationship. They also say, although Trump signed all these checks, that he in no way had anything to do with how the records were manipulated to change the nature of the transactions to hide the fact that they were a payoff. And they also say, by the way, even if you don't believe that and all that is true, then what he did was not a crime, because it's not a crime to try to influence an election. I gotta call it like I see it. That dog just doesn't hunt. That's what I call a shotgun approach. What that means is there's no clear, viable defense. So what the defense is doing is throwing up all these different theories and possibilities, hoping something sticks and hoping it resonates with the jury. And I gotta tell you, if you're a defendant looking on the barrel of a felony conviction in prison time, that is not the defense you want your lawyer to be using. What that tells me is the defense knows they really can't challenge the facts as alleged by the prosecution in this case, that they're not going to beat them on that. So what they're trying to do is present some alternative theory or rationale or way to interpret those facts. And I want to be clear, there's nothing wrong with presenting an alternative version of the facts or some type of theory that is consistent with a defense. However, if you're going to do that, it's got to be realistic. It's got to be something a jury can wrap their minds around, something they can think about and say, you know something, that makes sense to us, and something they can use to find a basis to find a person not guilty. But I just don't see a jury buying it. I mean, I don't see a jury buying that, just because, some random woman made a false allegation about something that happened a decade earlier that didn't happen, for which there's supposedly no proof. They would have his personal lawyer and David Pecker running around, going to all this trouble, making this big payoff to make it go away, just so his wife won't hear about the allegation. I mean, the jury's not going to believe that. And then to tack on that lame argument at the end that even if he did do it, it's not a crime to try to influence a presidential election. I mean, all that reeks of desperation. So yes, he should be concerned. Now, another strategy, and I'm certain This is not something Trump would want to hear, and often it's something a lot of defendants in criminal cases don't want to hear. But sometimes you need to cut the deal. This is how I would handle the case. First, I would negotiate the charge down to a single misdemeanor, because he is charged with misdemeanors as well, in addition to the felony. I can guarantee the prosecution would go for it because they would consider anything against him a win. Next, I would negotiate a fine with no chance of prison time. Again, the prosecutor would take it as a win, and of course, Trump can afford it. I would also negotiate, allow him to plead no contest instead of guilty. Now, no contest has the exact same effect as a guilty plea when it comes to the penalty. However, if a defendant is allowed to plead no contest, what that means is he doesn't have to publicly go into court and admit he did anything wrong or say he's guilty. What that allows a defendant to do is say, listen, I understand there are facts and allegations against me. I don't want to fight it. I want to pay the fine and move on with my life and be done with it. Next, Trump could easily say, look, I'm a public figure. I'm always the subject of false allegations and frivolous lawsuits, and sometimes it's easier for me to pay the money, make it go away, so my family doesn't have to deal with it, and I'm not distracted from my business. He could then say, campaign laws are complex, and when I handled the situation the manner that I did, I was not aware, because I'm not a career politician, I was not aware this might violate campaign finance laws. And now that this is over, I want to get back to making America great again. Plain and simple, and he'd be done with it. He could get back on the campaign trail. I can guarantee you this would not hurt his chances of being reelected in the least. His supporters wouldn't care, voters wouldn't care. Now, realistically, we all know that Trump would never agree to that in a million years. But as someone that has spent 30 years handling criminal cases, I say it is a mistake to always consider criminal cases with a zero-sum game mindset or an all-or-nothing mindset. Sometimes you have to look at the big picture and think about what decision allows you to be safe, have some control over the outcome that you can live with, and one that's going to allow you to move on with your life and do the things that you want to do. You have to put your ego aside and think in terms of risk management. What's the best way for you to accomplish your long-term goals? That's what I say to all of my clients when they're trying to decide whether or not to go to trial or to cut a deal. Well, what do you think of Trump's defense strategy? And what do you think of my strategy? Do me a favor, leave your comments, and call it like you see it. That's it. Well, I hope you enjoyed that. There are so many topics to talk about. I appreciate you taking the time to join me on this legal deep dive, but please subscribe, leave me your comments, and tell me the legal issues you want to talk about. You can find me on YouTube, social media, and your favorite podcast platform. Until then, that's it.